So we're going to talk briefly, very briefly, about a sketch on limitation of liability. And what is limitation of liability? Is the ability of the ship owner to cap his financial exposure up to a maximum amount, nowadays based on the tonnage of his ship, regardless of the amount of claims that are brought against him. Of course, provided that claims that occur in direct onboard or in direct connection with the operation of the ship. Imagine that we're in port. Okay, imagine that we're in port, and this is the ship. And this is the ship. We're in the quay, and I die here on the quay, not on the ship. Here on the quay. Would the ship owner be liable? You know, and people answer and everything, and the students usually at Hindi laugh because I tell them my favorite answer is it depends. You know, if I die of a heart attack, if I trip and crash my head on the floor, no. But imagine, for example, there's a container being unloaded and it lands on me or something like that. That's something that occurs in direct connection with the operation of the ship. So we have to link that claim somehow to the activity of the ship. And if that is the case, all the claims, regardless of the amount that can be brought, are arising out of one incident, are brought against the ship owner, they would have to compete against one limitation fund. An example, everyone knows this ship, the Titanic. The claims for the loss of life in the sinking of the Titanic amounted to $22 million. But the fund established based on a few lifeboats, unpaid passage monies, etc., was just $91,805. So you see that regardless of how much they were claiming, regardless of the 22 million they were claiming, the ship owner would only be liable up to 91,000. And this is something very interesting. Why does this arise from a historical standpoint? Let me see, I think because I deleted a lot of the history. And from a historical standpoint, you know, it was recognized, I have a ship and I start carrying cargo. And in history, sometimes the cargo was valued much more than the ship itself, you know? So the question was, if the ship goes down, do I have to go down with the ship, you know, financially speaking? So they started with insurance, general average provisions, etc. But limitation of liability was key to ensuring that viability and promoting the shipping industry. Let me give you another example in modern times now, the grounding of the Ever Given. As you may remember, the Ever Given in March 2021 ran aground blocking the Suez Canal for around 6 days, and it faced claims of $916 million, including $300 million for loss of reputation. Now, we will see soon the different conventions that were available, and in this case, Egypt had done a bit of a mistake, in my opinion, and they were suing in Egypt at all costs, where Egypt is only a party to the 1976 convention. And the limit of liability, if I recall correctly, was around $32 million or $36 million. Whereas under the 1996 protocol, the limit, I think, was $118,000. It was much more. But the ship owner, knowing what we were discussing as the different jurisdictions, knowing that he may be sued in different jurisdictions and that the 1976 fund may not necessarily be recognized, he constituted a limitation fund in London under the 1996 protocol, so the fund was much higher. But still, from 916 million, only thing he had to pay was 118 million. Now, what we will be speaking here, my colleagues will be speaking about specific points, but I will be talking about what we call global limitation of liability. And global limitation of liability must be distinguished with what I call particular liability regimes. Why that distinction is because LLMC convention, which we will discuss now, is exclusively a limitation of liability convention. It doesn't tell you who is liable or what are the bases of liability. You may find that in contract, you may find that in tort, etc. It only tells you who can limit liability, up to how much, for which claims, and procedure, etc. Whereas other conventions, like the ones that my colleagues will be discussing, give you basis of liability, for example, whether it's fault-based, whether it's strict liability, etc., and maybe limits of liability in certain cases. So you have to distinguish between global limitation of liability and particular liability regimes. Now, this is a graphic I came up with quite some time ago, and It happened that when I was doing my PhD, I came up with this scenario in my head that I thought it was a nightmare scenario that was impossible to happen. And it's a nightmare scenario for the persons involved, a dream for the lawyers. Imagine that you have a cruise ship and there is a tanker and they collide out at sea. There is explosion and fire on board the tanker. There is loss of life or personal injury of the crew of the tanker. There is loss of pollution, like oil pollution, because of the cargo of oil. There is pollution from bunker oil from the cruise liner. There's loss of life of passengers. There's loss of life of the crew of the passenger ship, which are two different regimes. And then the ship sinks and becomes a wreck, and we have to remove it. And the question will be there, which regime will apply? And there is an amazing interaction between conventions when it comes to this point. And once I thought it was a nightmare scenario, impossible to occur, I came across the case of the Doña Paz. I'm not sure if you're familiar with it, but the Doña Paz was a passenger ship that collided with a tanker called the Empty Vector off the coast of the Philippines 5 days before Christmas in 1987. Only 24 persons survived the tragedy, being rescued by vessels in the vicinity. I would invite you, I'm sure in YouTube you find that there is a National Geographic documentary. It's called Asia's Titanic, and it's a dramatic incident what happened here. The Coast Guard clearance had as a passenger list 1,493 in the Doña Paz, but it seems that there were over 4,000 persons on board, and in fact it seems that the death toll would have been over 4,400. Now, and this is a question, you say, but how come? You say, imagine that you're on a ship, everybody's partying, it's Christmas time. You see the tanker coming, bells start, all the sounds start going off, you know it's going to crash. There is a collision. You survive the collision, okay? You know your ship is going to sink. So what do you do? I'm thinking, you need to survive. So anyway, your ship is going to sink. You're in the middle of the sea, what do you do? Okay, exactly, but there was one problem. The sea was on fire. Because the oil pollution that was, not pollution, the oil that was spilled from the collision immediately caught fire. So those who didn't drown were burnt alive. And it was a real tragedy. So the interplay of conventions, you would have LLMC, if there were parties and applied, you would have LLMC, you would have Athens, you would have CLC, you would have probably have of the carriage conventions for the loss of cargo loss, you would have had a bunker oil convention, you would have CLC for the oil pollution, you would have wreck removal, all of them with one or another interplay. In fact, that was the scope of my research, how these conventions will interplay. Now, one of the things is that imagine that the ever given, as we say, was 916 million in claims and only 100 million paid. You say, is there justice in this? And Lord Denning, when he discussed the Branly-Moore, didn't think so. He said that limitation of liability is not a matter of justice, it is a rule of public policy that has its origins in history and its justification in convenience. This is one of the most celebrated passages on limitation of liability. Whether I agree or not, we will revisit this at the end of this section of the class. We're not going to go through this, but throughout history, there were different systems of limitation of liability. The traditional in continental Europe was limitation of liability by abandonment. Imagine, for argument's sake, that your ship costs €1 million and it runs aground, becomes a wreck, and as a result, the post-accident value of the ship is just 100,000. So, are you liable for the 1 million that it usually costs or the 100,000? What you would do is abandon the ship and freight and tell the claimants, you know, you're all suing me, there's the ship, kill yourselves, you know, I mean, fight for the fund, I don't care. But I wouldn't have any personal liability beyond that. It was just what I was left. That's what's limitation of liability by abandonment. But with time, things change, and the modern approach is limitation of liability by tonnage. So depending on the tonnage of the ship, there will be a specific amount per ton that will be paid. There has been a development in international regulation, having a convention in 1924, one in 1957. The most common was the 1976 convention, which we call it the LLMC convention. And then this was amended in 1996 by a protocol, which in turn, the limits of liability were further increased by a resolution of the IMO Legal Committee in 2012, and the new limits of liability entered into force in 2015. Now, there are many countries, as we will see, that remain a party to the 1976 convention, but most countries nowadays are party to the 1996 protocol. So what we'll do is that we're going to discuss this convention as amended, as one, rather than discussing them separately. So we're going to discuss the LLMC convention as amended. We start first with the persons entitled to limit liability. The list is short. In fact, Article 1 says ship owners and salvors are entitled to limit liability. But the definition of ship owner is wide. Unlike others, for example, if you go to the CLC, it says the registered owner. But in this one is wide. It's the owner, which can be the registered or beneficial owner. It includes the charterer. It includes the manager or the operator of the ship. All those fall within the definition of ship owner under the LLMC convention. You have the salvors. You have any person for whose act, neglect, or default the ship owner or salvor is responsible, and the insurers of liability. I'll come back to these ones now. Some important points. Since the convention addresses the persons who are entitled to limit liability, lawyers may be clever enough and say, okay, so I don't sue the person, I will sue the ship. As a legal person and an action in rem. But the convention caters for that, and it says that in this convention, the liability of the ship owner shall include a liability in an action brought against the vessel herself. So whether you sue the ship or the ship owner, the limit of liability would still apply. And the other point is that the act of invoking limitation of liability does not constitute an admission of liability. And why do I emphasize in this? Because one of the first things, and I always say, every lecturer that stands before you will tell you, my topic is the most important. Everyone. One of the curious things about this is that this time is true. No, I'm joking. No. One of the most curious things about this is that the first call that you have with the ship owner, you will tell this and this happened, I'm holding you liable, you caused me all this damage, and he will tell you, just a minute. There is something that is called limitation of liability, so forget what you think you lost, this is as much as I am liable to pay, let's discuss from here down. And that's where the discussion starts. And he will challenge the liability itself, but limitation of liability would be that first discussion that you will have always. Now, we spoke of the owner. And in the charters, it includes all charters. It includes the voyage charter, the time charter, the bareboat charter, even sub-charterers. But the question had arisen whether slot charterers are covered because they just hire a bit of space in the ship. In the UK, it is clear now. And in the case, there was the case of the Taiki that dealt with arrest before that shed some light on this. But in the case of the MSC Napoli, dealing specifically with the convention, the court said that in accordance with the ordinary meaning of the word charter and in light of the evident object and purpose of the convention, a slot charter is within the definition of ship owner and therefore is entitled to limit liability. Now, this is what the English court said, but the convention only says charters. Whether all courts would agree with this, I'm not sure. Some 15 years ago, the CMI had done a bit of a study, and I recall that countries like Argentina, Spain, I believe Mexico, had opposed to the notion that the slot charter should be entitled to limit liability. And on other presentations, I understand why, because there's a very close relationship with volume contracts, which would be a shipper trying to invoke a right to limit liability that is not covered. In any case, if a slot charterer is granted the right to limit liability, he will not limit liability just on the slot he chartered, but based on the full tonnage of the ship, like the ship owner as well. So slot charterers are entitled to limit liability as per the interpretation of the UK. Now, managers and operators, this is something quite interesting. If you see Griggs, Williams, and Farr, which have written the Bible on limitation of liability, they say, for example, that crewing agents are not covered by the convention because they don't have a full interest on the full vessel, you know. And so that I agree or disagree, again, my answer, it depends. And in the case of ASP Ship Management versus Administrative Appeals Tribunal, the full Federal Court of Australia held that operated by, in other words, falling under operator, involves notions of a real, substantial, and direct role in the management and control of the commercial, technical, and crewing operations of the ship. Now, if you go to the BIMCO forms, there are two forms, crewman A, crewman B. In one of them, the agent just acts as an intermediary. So the contract is between the owner and the crew, and I just put them together and each of them signs. So I don't have any liability. I wouldn't be entitled to limit liability. But in the other form, you engage me and tell me the crewing of the ship is your problem. I have nothing to do with that. That's what I'm paying you. And then I go as a principal to engage the crew. So in that case, I am performing the functions of the ship owner, and I would be encompassing on the role of operator. So whether the crewing agent is a part of the operation or not, then it depends on his role. Salvors in the earlier conventions were not covered. And one of the most important cases that led to this change was the Tojo Maru, that a diver was sent to put a bolt gun to seal the hull of a ship. But he was told to wait until the tanks were fully degassed. But he thought he didn't have to wait, fired the bolt gun, it was a huge explosion, huge damage, etc. When the claim came before the House of Lords said, just a minute, this did not happen on board the ship, the salvor was underground, and this did not happen in the management or operation of the salvor tug, so limitation of liability does not apply, because it was only of ship owners. Now, the convention, to cater for this, mentions salvors as having an express right to limit liability. Now, sometimes it's not the ship owner that causes the damage, it may be his crew or other persons. So, in Adler versus Dickinson, I'm not sure if you're familiar with this case in general, particularly those are seeing us online, but I'm pretty sure that when you studied carriage of goods by sea, you heard about the Himalaya clause. And it comes from this case, because in this case, the plaintiff got injured coming down from the Himalaya. The gangway gave way and she fell. And instead of, she went to the lawyer and said, listen, the owner has a right to limit liability. I said, but the crew doesn't. So instead of suing the ship owner, they sued the master and the boatswain, and the Court of Appeal did not consider that in this case, the ship owner had contracted with the passenger as agent of his servants. And as such, any immunity available to the ship owner could not be extended to the servants. Thank God. So in 1957, the convention covered also the servants of the owner. And that's how the Himalaya clause extend the provisions of those involved on behalf of the owner to be covered the provisions of the relevant treaty. However, the LLMC convention went a bit beyond, and it doesn't speak of servants. It speaks of any person for whose act, neglect, or default the ship owner or salvor is responsible. So, do they have to be their employees? Does it cover independent contractors? Under the general law, vicarious liability arises only from a contract of service, but not a contract for services, the exception of pilotage, perhaps. So, in this case, by using the words is responsible, the convention has extended this to the crew, as it was logic. For example, to stevedores on the port. Imagine that the ship has no crane, it has to use a shore crane to unload the cargo. Stevedores are independent contractors. But there was a case of the case of the White Rose, where the court said that once the ship owner has acquired an obligation, he cannot hide from the fulfillment of the obligation by engaging independent contractors. And therefore, the stevedores would be covered. Now, Aleka Mandaraka Shepard goes a bit beyond, and I really like the definition. says that these persons would have to prove that they are performing a non-delegable duty of the ship owner. In other words, the ship owner is responsible at law for their actions. For example, who's responsible for the seaworthiness of the vessel? The ship owner. So the ship repairer, in ensuring the seaworthiness of the vessel, is carrying out a ship owner's obligation. Liability insurer, of course, the insurer will be liable or will be entitled to limit liability to the same extent as the assured himself. Let's run to the list of claims. God, we're late already. First is loss of life or personal injury, or loss of or damage to property occurring on board or in direct connection with the operation of the ship. Second is claims resulting from delay in the carriage of sea of cargo, passengers, or their luggage. Now, this, when the conference met, it was highly debated because they said it's not covered, it's not necessary. If the ship runs aground, there's loss of damage to property. There is a delay, it's a consequential loss from the loss of or damage to property. But they said that is in the case of what we call concrete damage, like in the second scenario. But what about, imagine, those ships that were sued because the goods got delayed because the Ever Given had blocked the Suez Canal, and they are waiting outside, but there's no concrete loss. So they were saying in the concept of abstract loss, they would be able to limit liability for delay. Then is claims for infringement of rights other than contractual rights. Here I was mentioning why I put the picture is because what if freight is affected? Freight will not be covered because it's a contractual right. This provision emphasizes, for example, when there is a right of passage over a bridge spanning a sea and it is broken because of the ship, when a ship runs aground at the mouth of the harbor and prevents access to ports from other ships, something like that. One of the most important claims are wreck and cargo removal. Those are subject to limitation of liability. And if you speak about wreck removal, you will see that the convention provides for strict liability, but it doesn't provide limits. It ties them to the LLMC. So you may have strict and limited liability. If I recall correctly, my memory is not my best asset anymore, but if I recall correctly, the calculation of the limit of liability of the Costa Concordia was around $58 million. But the loss cost or the costs of removing the wreck were almost $1 billion. So if there is limit of liability, who will pay the difference? The government, the taxpayer. Because you cannot just leave it there. So it is very important, in my opinion, to remove these two provisions from the scope of application of the LLMC. And it's one of the in fact, in 1976, it was the only reservation that was available under the convention. Let me just jump this one. And claims will be subject to limitation whether they are brought directly or as indemnity. Excepted from limitation, the first are claims for salvage and contributions in general average. The slides have a bit more graphics, and if you circulate them for more information, but unfortunately we're time restricted. When we speak of claims for salvage, we're speaking of direct claims from the salvor, not claims of indemnity arising from a salvage operation. So for example, just briefly, in this case, the salvor is entitled to claim the ship salvage from the ship owner, and the cargo claimant from the cargo owners the claim for the cargo salvage. Both are not subject to limitation of liability. But when the cargo owner claims compensation or indemnity from the ship owner, that would be subject to limitation of liability. And the reason is that the cargo owner's claim against the ship owner would be subject to limitation because it is not a salvage claim anymore. It is a claim for breach of carriage contract. So it has lost its identity. So when we speak of claims of salvage, are direct claims brought by the salvor. We have also claims within the meaning of the CLC, of the Civil Liability Convention for Oil Pollution Damage. So technically, when it says within the meaning, you don't have to be a party to the convention. It doesn't have to apply if it falls within the definition. In other words, if it is pollution by persistent oil from a tanker, it will not be subject to LLMC. Then you have nuclear claims. And you have claims also if the law governing the contract prevents limitation of liability. And imagine your employment law says that an employer cannot limit liability for any loss of life or personal injury of his employee. If the law or the contract prevent it, they will not be subject to limitation of liability. Now, the conduct preventing limitation. This was very interesting because until 1976, the right to limit liability was lost by fault or privity of the owner. So it was very easy to break the right to limit liability. In fact, it depended on the judge who came before. If he liked the concept of limitation of liability, he would very say there's no loss of, there's no privity or fault. If he didn't like the concept, it was for sure he will find a way. So Gilmore and Black, who were two American prominent writers, said that the phrase was devoid of meaning, an empty container into which courts are free to pour whatever content they will. It was useless, basically. Now, the 1976 convention took a much more strict approach. And it said that a person liable shall not be entitled to limit his liability if it is proved that the loss resulted from his personal act or omission, committed with intent to cause such loss, or recklessly, and with knowledge that such loss not would possibly, but would probably result. The test, it was meant to be virtually unbreakable. And it was accepted because against this virtually unbreakable right to limit liability, they increased the limitation, the limits of liability. If you see here, most conventions, most modern liability conventions use exactly the same formula, with the exception that the LLMC says a person liable and that talks of loss. Athens speaks of the carrier and speaks of damage. CLC speaks of the owner, speaks of pollution damage. But the rest, they're virtually the same. So why do I emphasize this? Still, courts were finding a lot of circumstances in which limitation of liability would be lost. And particularly, intent is very difficult to prove, but recklessly, they were finding, and they were saying is if you act in a manner which indicates a decision to run the risk or a mental attitude of indifference to its existence. French courts, there are a lot of examples where breaking the right to limit left, right, and center, and the English lawyers were quite upset, and they said that the French didn't know what they were doing. But then in 2003, the case of the Saint-Jacques number 3 came before the English court. And Grosjean denied an application for summary judgment in a limitation action because he thought that if it went to court, if it went to trial, there was a real prospect of succeeding in proving the conduct of Article 4 because of the obvious risk of collision. If you see here, this is the Saint-Jacques number 2, and he really wanted to get fast to fishing grounds on the other side of the traffic separation scheme. So instead of following the traffic separation scheme and coming around, he decided to cut across. And there was obvious that there were a number of ships coming the right way, and he went the wrong way. So I said, if it goes to court, most probably you will lose the right to limit liability, so I'm not removing it. So then even in the UK came the possibility that it could be removed. The case was probably settled out of court. There are no reports after that. But courts, it showed that there were a lot of different interpretations. In IMO, they used to ask them, listen, what does this mean? And IMO's reply was, listen, it's not up to us to interpret the convention. So what they did is IMO served as a forum, and state parties to the conventions adopted 3 resolutions on the test breaking the owner's right to limit liability. And this is, Maya, take note of these numbers, this is resolution 116332, which deals with the LLMC 76, 1164, which is the LLMC protocol, and 1165, which is the CLC protocol. One thing that I found very interesting is that, speaking of course in Athens, they didn't do a resolution for Athens. So does that mean that Athens is to be taken in a different approach? Now they say, no, it's because it's the same thing. But obviously, if they follow for all the conventions, it's quite curious that they didn't do one for carriage of passengers. The resolutions are a bit long. There are 21 recitals, but they only have 3 operating paragraphs, in only one with substantive content. This is just the generality. And this is important. They recognize that the state parties are the final arbiters on the interpretation of the convention. IMO cannot do it for them. So the state parties affirm that the test for breaking the right to limit as contained in Article 4 of the 1996 LLMC Convention, and this is the only thing that changes, whether it's 1996 Protocol or CLC, as virtually unbreakable in nature, breakable only in very limited circumstances based on the principle of unbreakability. And B, to mean a level of culpability analogous to willful misconduct, namely a level higher than the concept of gross negligence, a level that will deprive the ship owner of the right to be indemnified under their marine insurance policy, or a level that provides that the loss of entitlement to limit liability should begin where the level of culpability is such that insurability ends. So now it is quite, sorry. What happened? Okay. Now it is quite clear that it should be virtually unbreakable. Now, recklessly, they said the term recklessly has to be accompanied with knowledge. You cannot just be reckless and not knowing what will probably happen. So the two terms will stand or fall together. They cannot be treated in isolation. And the conduct of the parties, other than the ship owner, for example, the master, crew, servants of the ship owner, is irrelevant and should not be taken into account when seeking to establish whether the test has been met. In fact, see here, the master, crew, or servants. There was a case, I had cited it in my book, I forgot it by now, but they were using an anthropomorphic description, comparison, and said, there are some persons that act like the brain of the company, and there are others that act like the hands of the company. So those acts of the hands would not prevent the brain from limiting liability. Those that are the brain, then yes, so if it's one of the board of directors, the ship owner, or someone very, very high up, you may lose the right to limit liability. But those on board the ship are acting like the hands of the body that will not prevent the owner from limiting the right to limit liability. Let me just jump this counterclaims. Sorry. Now, limits of liability. Let's focus on the principles. There are two limits of liability calculated under the LLMC Convention. Sometimes, perhaps wrongly, I say two limitation funds, but as we were discussing before, sometimes the limitation amount is calculated by a fund is never constituted. So there are two limits of liability, one for loss of life or personal injury, and one for any other claims. So usually authors refer to it as personal claims or property claims. And these limits are calculated using a sliding scale, so there are different tiers of liability, and the bigger the ship, the less they pay per ton. Let me give you just an example here, which we will. If you see, in respect of the first 2,000 tons is 3.02 million, but then for the first tier is 1,208 per ton, the second tier 906, the third tier 604. The more the ship, the more tons the ship has, the lower it pays per ton. So there are different limits of liabilities. Now, since there are two limitation amounts, it's important to know that if the limit of liability calculated under Article 6.1a, in other words, the personal claims, is insufficient to pay the loss of life claims in full, then the fund for any other claims will be available to pay the unpaid balance. This is called the overspill provision. These are other things. We don't have much time, unfortunately. This is what I was mentioning, calculation of the limit in the ever given. Under 1976, it was $32 million. Under 1996, it's $116 million. So it is very important that states that are still parties to the 1976 Convention denounce the Convention to protect the claimants and become parties to the 1996 Protocol. One thing I will mention towards the end is that unlike other protocols that say to become a party to this protocol, the party has to denounce the earlier convention, LLMC does not do it. And there are states that will run into a lot of problems afterwards that have become a party to both conventions. So they became a party to the 1996 protocol without denouncing the 1976 convention. This we spoke already. Limits of liability for passenger claims, just briefly, because they will be discussed. The 1976 convention, the 1996 protocol rather, puts that it's not based on tonnage anymore. It's based on the carrying capacity. And it put it at 175,000 multiplied by the number of passengers the ship is certified to carry. But 15.3 bis provides that if a state thinks that this amount is too low, they can put the amounts higher. There have been several approaches. For example, Malta says that any claim for passengers will be regulated by Athens. The UK says that it will not cover, LLMC does not cover claims for passengers, it just leaves them out. It doesn't say what will govern them, but it will be Athens. Now, when I had done my research, I thought that although the 1996 protocol could not be amended on that point, at that point, insofar as passengers are concerned, until such a time as it was amended, states should take action and should try to harmonize. It's a whole new discussion, so I cannot go into it for time, but to harmonize it with the 2002 protocol. So at least the limits of liability should be raised to 250,000 special drawing rights. And the declaration by Sweden took up the proposal, and it says that national law in Sweden will, as from 2nd September 2015, provide a higher limit of liability in respect of claims arising from the loss of life or personal injury to passengers to 250,000 units of account. And the same was done with Finland, 250,000 units of account. Now, this is what I was mentioning before from the countries of the alliance. You have Albania is a party to LLMC 76 and 96. Croatia is a party to both. Italy was a party to none, Montenegro was a party to none, I'm not sure if that's it. And Slovenia had announced and had become a party to the 1996 approach. So it is very important, for example, in the case of Croatia, that they would deny the 1976 convention. If not, what will happen, and this is something, if not, what will happen is that if there is a case with multiple claimants and the ship owner chooses to constitute, like I mentioned in the ever given, chooses to constitute a fund in a 1976 country, you will have to accept it because you have international obligations to the other state parties. You know, even if you say no, but my national law says 1996 protocol, it doesn't matter. Because if the other lawyer brings out the Vienna Convention on the law of treaties, can tell you, well, a provision of national law cannot be used as an excuse not to comply with an international obligation. And you have an obligation still under the 1976 convention. And these things will happen. So those states that are a party to both, technically they should choose, and my opinion would be to go to the new convention. The unit of account is the special drawing right. Aggregation of claims. I will just stop here because it's a bit of elaborate. Imagine that one match is lit and it caused damage to 1, 2, 3, 4, 5 vessels. But there's only one act of negligence. That means that the claims of the 5 claimants will have to be brought against one action, against one fund. If, of course, there are different acts of negligence, you may be required to constitute different funds. Because the idea is that a fund will apply to all the claims that arise on any distinct occasion. One act of negligence, one fund. Several acts of negligence that break the chain of causation, different funds. The limitation fund. The limitation fund will be can be established in any court in which limitation is invoked. Let me see, just a second, sorry. Up. Let me see if I can. Okay, this was important. I mentioned before. So a court can calculate a limitation fund and authorize it, but that does not require the ship owner to actually deposit the money in court. So you may be negotiating throughout. In fact, I was discussing, we had a case in which the court in Singapore said, this is the limit of liability, and we were negotiating throughout, and actually the case was settled, and the fund was never actually deposited in court. There is no obligation. There are other conventions that would require you. If you want to limit liability, you have to deposit a fund. The LLMC does not. But it allows state parties to say, you can require it. Spain, for example, says, if you are going to limit liability in Spain, you have to deposit a fund. But the convention itself does not require it. It will be calculated in the amount set in Article 6 and 7. It can be by cash or by producing a bank, or not a bank, a guarantee acceptable under the laws of the state. In fact, I think it was 2014, if I recall correctly, that there was a case called the Atlantic Confidence in the UK, in which the court said, we don't accept a P&I LOU, you know, a letter of guarantee of a P&I club. We don't accept it because our rules of procedure say it is cash only. And they were right, but I wrote a case report, I did a criticism, and said the UK will actually lose as a competitive jurisdiction because other courts are accepting. Luckily, the Court of Appeal reversed that decision, and a letter of undertaking from a P&I club is now accepted. So you have to see what guarantees are acceptable in the relevant country. The fund is not distributed equally, but it's distributed equitably. It's based pro rata on the claims as established against the fund. Now, once the fund has been constituted, any person having made a claim against the fund shall be barred from exercising any right in respect of such claim, the claim in the fund, against any other assets of the person by or on behalf of whom the fund has been constituted. So just in relation to the actual claim. And if a ship had been arrested, it should technically be released. The governing law. Let me just jump because we're run. Now, unlike other conventions, we're not here dealing what is the flag of the state, what is the nationality of the parties. This is in a forum-based jurisdiction. If there is a jurisdictional link to any state and I invoke the right in A, that's where it will happen. So it depends on where the owner invokes the right to limit liability. That's why is this statement interesting? And it's because traditionally or historically, limitation of liability was a defense. In other words, I am sued, and I said, okay, I will defend myself, but I limit my liability. Whereas now, if I recall correctly, was the case of the Western region that allows the ship owner to issue what they call a preemptive strike. And I know you are all suing me, and I'm can be sued in Slovenia, Croatia, Montenegro, Albania, etc. So instead of waiting to be sued, I choose a jurisdiction and I sue, provided that it's not to the detriment of the claimants. Like, for example, imagine that you're all parties to the 1996 protocol, and Italy is not a party to any, so I constitute a fund in Italy at a lower amount. You will be prejudiced, you can object it. But if I choose a jurisdiction that is the 1996 protocol, no one will be affected as such. So that would allow me to do it before. So it's on a forum-based approach. Let me leave the scope of application.
Sorry, one question.
Yeah.
Now that you mentioned that, would in that situation rectify the problem of being a party to both parties?
No, because if I constitute a fund in the 1976 convention, you may be a party to the 1996. Imagine that you have 5 states being a party to the 1996 protocol, 3 states being a party to the 1976 convention, and another state being a party only to the 1976 convention. If I constitute a fund here, if I try to constitute it in one of the states, they would say you have to constitute it under the 1996 protocol, because the first, let's say, point of contact. But if I constitute it, not necessarily here, but I'm a party to both, but I constitute it here, that is only a party to 1976, these states have nothing to do with it, because they're party to 1996 only, and it's a different thing. I'll mention this after. So they still demand this. But these other 3 states can benefit from the 1996 protocol, but they have an obligation internationally to accept the 1976 fund. So then, imagine that you don't have a 1996 one, but if you have just 76 and 96, you have an obligation because you have not denounced that right. So you have in the Committee of Nations, you have that right.
Okay, but then two funds are going to be constituted?
Not necessarily. Not as forget that there are the five states that are parties just to the 96 protocol. Imagine that you have the 3 states that are party to 76 and 96, and you have one state that that is only a party to 76, and you constituted here. The states cannot demand it because they have an obligation
I
to accept.
understand that. But if you have those 5 states as well, that they're only parties to
They may demand it. They may demand it.
And in that case, another fund in full amount would.
That's a very important question. No authoritative answer. There was a case in Hong Kong some time ago that left a bit ambiguous. In fact, we argued before a court in Malta recently, and my argument was because they were arguing Committee of Nations that we were obliged to recognize the lower fund, and my argument in court was that once we were agreeing to recognize the existence of that fund, we were not bound by its limit. So as such, they could take that fund and the Maltese court could top it up to the 1996 protocol to cover the difference, for example.
And in that case, those states that are part of the proposed convention could benefit from that.
That again is a discussion, because if there was a lower fund constituted, as a lawyer of the ship owner, I say no, you have an obligation with this state, and you cannot have two bites at the cherry. So it depends on the arguments. I always say, if you tell me the sky is blue in court, I'm the judge. If you tell me the sky is blue, you tell me the sky is black, who holds the truth? No, this one. Who holds the truth? You are the claimant, you say the sky is blue. You are the defendant, you say the sky is black. I am the judge. Who holds the truth? Me. You have 2 sets of facts. The truth is what the judge decides, for good or for bad. So in this case, it depends on how the courts are persuaded. But there's no authoritative answer on that point yet. But it can certainly be a problem. Why I left this here is because whether a ship is 3 tons, 100 tons, of 2,000 or 2,000 tons, it will pay the same amount. And sometimes, because of insurance purposes, it's prohibitive for the very small ships. So the convention allows states to make their own limits for ships of less than 300 tons. In other words, for very small ships. In the states that have taken this option, which I would encourage to do, usually take half the amount of the limits provided by the convention. So you will have the limits of liability under Article 6 or 7, and for very small ships, it will be half the amount. But if the state has not taken that action, it will be the same for everyone. Let me see. This is scope. And just. The convention does not apply to air cushion vehicles or floating platforms. Now, reservations, this is very important. The 1976 convention only allowed reservations in relation to Articles 2(1)(d) and E, which is wreck and cargo removal. But why I mentioned something, because it's one of the things we do, I think we focus on drafting. And here, it says a state may, at the time of signature, ratification, approval, or accession, may reserve the right to exclude. And most states just copy and paste this approach. The Republic of Honduras reserves the right to exclude, for example. And that, to a certain extent, is wrong. And the 1996 protocol changed this. And it's, well, I'm not sure, I don't think I have, let me see, I don't think I have, no. There were some cases in France. And France, in 1976, reserved the right to exclude this. So they went to court, and the ship owner, the claimant said they made a reservation. And the other party said, no. They reserved the right to exclude it, but they did not exclude it. And it was a whole mess until on appeal by interpretation, they say that it was an effective reservation. In reality, it wasn't. And the reason for this, at risk of taking an extra 2 minutes, is that before, if you see here, you can only make that time the reservation at the time of signature, ratification, acceptance, approval, or accession. In other words, you can only make the reservation at the time of expressing your consent to be bound. You cannot do it after. So what states were doing is, since I don't know what I want to do in the future, I reserve the right to exclude it in the future. Of course, what used to happen, and this is quite funny, because again, I asked the students, so you forgot to do the reservation at the time of signature, ratification, at the time of expressing your consent to go. You forgot to do it. Something happened, and 10 years down the line, you decide that it was best if you had done the reservation. Can you do it?
Because
It says, no, you haven't reserved the right. You forgot. So here it said, signature, ratification, approval, or exception, and that passed. So what happened was, that lawyers are always clever, they said, okay, simple. Said, denounce the convention, then accede to it again, make the reservation. And it was effective, but it was a mess. So the Secretary General of the United Nations said, listen, this is ridiculous. Legally right, but ridiculous. So they started a practice of accepting late reservations. And they would circulate them, and if there was no objection, they would accept them. But to avoid this hassle, the new approach is at the time of signature, ratification, acceptance, approval, or accession, or at any time thereafter. And that saved the problem. But the reservation by Malta, it says, if you see here, it says, reserves the right to exclude. Lithuania, I like. Lithuania said that Lithuania hereby excludes. There's no doubt. Hereby exclude. But the 1996 protocol also allowed a reservation for HNS claims. But HNS claims are not, the HNS Convention is not in force yet. So, Malta, so many countries, again, have just copied that article, and the effect is that they have excluded HNS claims, even if the HNS Convention is not in force. So there's no, if there's an HNS incident, there's no limitation. Malta did it very cleverly in that sense, other than that part, and it excludes HNS claims which arise from occurrences which take place after the coming into force of that convention as part of the laws of Malta. So the reservation is valid now, but will only apply once the HNS Convention is in force. So you have the LLMC limits now, and as soon as the HNS kicks into force, you have the higher limits, but there will always be a limit. So these are some techniques that have to be thing. Lithuania, if you see here, says the Republic of Lithuania hereby excludes. This is what we're talking relationship. There are two different treaties, and it says a state party, which is a party to the protocol, but not a party to the convention, shall be bound by the provisions of the convention as amended by this protocol in relation to other state parties thereto, but shall not be bound by the provisions of the convention in relation to state parties only to the convention. So if you have that, a 1996 state and a 1976 state, you cannot, you're not bound to accept a fund in the lower spectrum. And this is why it's important to denounce the 1976 convention. And it says nothing in this protocol shall affect the obligations of a state which is a party both to the convention and to this protocol with respect to a state which is a party to the convention but not a party to the protocol. It's very clear there. It doesn't affect the obligations. So you have to respect the obligations of the 1976 convention. So that is a very dangerous ground. So to finish, does limitation of liability have a place today in today's shipping world still? In the Bramley-Moore, we mentioned, Lord Denning said that it is not a matter of justice. I had to change my hat a bit, and I was studying a bit of philosophy and economics in this case. And well, in the case of the Amalia, Dr. Lushington said that full indemnity, that natural rights of justice shall be abridged for political reasons. So if limitation of liability is contrary to natural justice, why follow it? So although it may be reasonable to consider the concept in the 1700s, when the loss of a ship or its cargo could bankrupt the ship owner, with the development of the modern insurance business, does limitation of liability have a place in today's shipping world? And this, when I was going through philosophy and economics, I came across the concept of this difference principle of distributive justice. And it says that social and economic inequalities are acceptable provided that, inter alia, they are for the greatest benefit of the least advantaged members of society. Therefore, if it is possible to raise the absolute position of the least advantaged further by having some inequalities of income and wealth, then the difference principle prescribes inequality up to the point where the absolute position of the least advantaged can no longer be raised. And this, sorry, they would circulate them just the same. And this is where the limitation of liability comes into play. What happens is, if there is an accident, the ship owner is liable. He will not bear that loss. What will happen is that he will include the cost of the loss in the freight that is being charged. The importer, who now has to pay more freight, will increase the price of the goods. The retailer will also increase the price of the goods, and the ultimate consumer is the one that is suffering. So whereas right now you want to make a plate of pasta and you go and buy a tin of tomatoes for €150, if you remove, that's because under the Hague Visby to bring the box of tomato tins, the ship owner has to pay X, €100 as a limit. But if you remove those limits of liability and there is no conception as how much he will be exposed to, that tin of tomatoes of €150 may cost you €15. The cruise that you pay €900 right now will cost you €5,000. So the mere concept of limitation of liability is providing a safety net to the least advantaged members of society, because it provides certainty to the ship owners about their potential exposure and enables the respective insurers to maintain the cost of insurance premium. This in turn allows those who are involved in the maritime industry the possibility of maintaining competitive prices and therefore benefiting the ultimate consumer. So in conclusion, if we agree on the discussion that we had, it may be reasonable to argue that limitation of liability is essential to the maritime industry. It has been come under attack, everyone trying to exploit it, but in my opinion, it's essential to the maritime industry. And if notwithstanding this view, one may wish to demonize the concept, limitation of liability must be considered as a necessary evil. One, which in my opinion was created to protect a few, as the ship owners, but now it could be argued serves as a safeguard to protect society as a whole. That's a very brief introduction.